Hi, everybody. Now, officially, it is my pleasure today to introduce the second cycle of our lecture series, online lecture series in Rule of Law and Democracy. Thanks for being here. First, let me say for some last-minute issues, 3 persons that had contributed enormously to this project cannot join us today. Professor Günther Frankenberg, who was planned as one of the commentators, Dr. Sofie Møller, who is one of the organizers of this event, and our managing director, Rebecca Schmidt. The 3 of them are very sorry about canceling due to some different issues and send their apologies to all the participants. Let me mention that this is the second year that we are organizing this online lecture series, and we are delighted to count again with an incredible group of scholars that had accepted our invitation. On the behalf of the organizing committee, let me thank to the speakers, to the commentators, to the Research Center on Normative Orders, and all the participants that had connected today. For today's lectures, it is my real pleasure to introduce our main speaker and our main commentator of the session. Professor Neil Walker will deliver today's lecture. Let me say some words about Professor Walker. Neil is the Regius Chair of Public Law and the Law of Nature and Nations at the University of Edinburgh. He has held various visiting appointments, including visiting professor at the University of Tilburg, visiting professor of law at the University of Columbia. He has held the Eugene Einaudi Chair of European Studies at the University of Cornell, and he has been a distinguished visiting professor of law at the University of Toronto, a global professor of law at New York University, a Sidley Austin Robert McLean visiting professor of law at Yale Law School. I can continue with so many other incredible visiting positions that Professor Neil Walker has held. But to summarize, let me also mention that among his many publications, he's the author of the famous monograph, Intimations of Global Law, that was published by Oxford University Press in 2014. Also, let me introduce our distinguished commentator, Professor Sandra Soriber, who is professor of political theory here at the Goethe University in Frankfurt, and is a current Goethe Fellow at the Institute for Advanced Studies at the Goethe University in Frankfurt. She has held visiting appointments, such as the Alfred Grosser Visiting Professor at Sciences Po Paris, and a visiting scholar at the New School for Social Research in New York. Professor Soriber did her bachelor and master in political science here in Frankfurt and her PhD in political theory in Berlin, the last one under the supervision of Professor Axel Honneth. Before holding her current chair in Frankfurt, she was research assistant and teaching assistant at the Freie University in Berlin and assistant professor at Potsdam University. Let me now give the word to our main speaker, Professor Neil Walker. The floor is yours.
Okay, thanks very much for that introduction, Carlos. Can I just check that everyone can hear me? Okay, yeah, okay. So I was going to say it's great to be here, but you know what I mean. It'd be even nicer to be there, but it's nice to be able to connect, and it's many years since I spoke in Frankfurt. I have fond memories. I think it was actually during the 2006 World Cup. I don't know why that came back to me, but it's true. Apologies, I don't have any PowerPoints, because I always feel that in these sorts of occasions, there's already a remoteness about not being there. And if you add PowerPoints, it can create a kind of double remoteness. So even though perhaps I should have PowerPoints, and I sometimes do, I'm going to try to do this without it. But so hopefully that works okay. Right. And I'll speak for about 40 minutes, that's okay? Yeah, okay. So the title is the Burden of the European Constitution. And there was a terrible moment when I was writing this paper last year that I realised that I can no longer use the term we when we're talking about the European Constitution, because I come from a Brexit country, and it felt like someone had ripped away my birthright. You know, when I, of course, I knew that intellectually, but I didn't really know it emotionally until I started thinking about and talking about the idea of a European Constitution again. So I look forward to a day where I can say we again, but we'll come on to that. So the burden of the European Constitution. So there are three questions which I pose at the beginning of the paper, right? And these are fundamental questions which I try to answer. One is, why, with varying degrees of intensity, has the European Union constitutional debate always been with us in some shape or form over recent decades? That's the first question. So the second question is, why, despite this sustained attention, it goes up and down, but it's always there, do optimistic views remain so scarce on the ground, either as to the prospects of the successful production and ratification of a canonical Big C constitution, or even if such a prospect were to be realised, as to the likelihood of that documentary achievement augmenting the legitimacy of the EU? That's the question 2. And the third question is, why nevertheless can't we get away from it? Why nevertheless is it so difficult to imagine the debate over a written constitution for the EU just fading away and being consigned to the dustbin of history? So these are the three questions which I'm trying to engage with. And of course, these questions have required a renewed urgency as we contemplate the latest attempt to reset the European project, the Conference on the Future of Europe, which just finished in May. Now, I'll say a little bit more about that in due course, but at the moment I just want to mark it as something which happened, a joint venture of the European Parliament, the Council and the European Commission, with all sorts of citizen involvement, concluding its work in May 2022. And of course, in the concluding ceremony, Emmanuel Macron actually mentioned the C word, the constitution word, and saying, well, maybe this is a time to think about launching a new constitutional project. And apparently at next week's council, he's going to say something similar, or perhaps develop that a little bit more. And what I thought actually was that I mean, this has been a European initiative with quite radical polity-wide ambitions, yet, like many before, it didn't actually have explicit constitution-making intent, including the actual aborted constitution of 2003. It started off as a kind of leftover IGC after the Treaty of Nice type process, and basically Giscard d'Estaing, who was the president of the convention, turned it into a constitutional project. And my point is, there have been many kind of polity-defining or redefining events in the EU's history, especially over the last 30 or 40 years, around which constitution talk has circulated, sometimes in whispers, sometimes more loudly. Okay, and the interesting thing about this one, I think, is that quite often in the past, this has been very much it's been a sign of success. In 2002, 2003, it was, let's push forward. This is a time where we're moving towards some kind of quasi-federal Europe or whatever. This is a time for the European Constitution. There isn't that sense this time, and that's important. That's something which we'll talk about. There's much more of a sense of crisis and response to crisis. And one of the points I make is that most constitutional debates, are around, or most European constitutional debates have circulated around the idea of what you might call the ontological function, a fancy way of saying what kind of polity actually is this. But this time, you get a sense that the ontological debate is kind of twinned with a more fundamental existential debate, which is, regardless of what kind of entity is this, can it indeed survive? Can it survive in the medium term or in the long term? And so if you look at the telling headline of the joint declaration which launched the conference, engaging with citizens to build a more resilient Europe, this idea, that of keeping something going, you know, consolidating, ensuring the resilience of the entity, rather than necessarily thinking in terms of expansion or whatever. And so that there's that kind of sense, and also the whole sense of sort of crisis which surrounded the convention, the fact that it was delayed for a year, at least partly because of the coronavirus, although that also masked the fact that there had been all sorts of interinstitutional disputes about how to actually run the convention. And also, as it drew to a close, you know, all attention was diverted to Ukraine for obvious reasons. So the convention itself was bookmarked by these two kind of crisis events, which tend to put the convention, or sorry, I keep calling it a convention, the conference itself into the shadow. So basically, my answer to these three opening questions, as I'll try to develop that answer over the next 30 odd minutes, is it lies with what I call the burden of the European Constitution. And that explains my title. You know, the idea of a self-proclaimed big C European Constitution and of constitutionalism generally, including small c constitutionalism, means many different things to many different people with many different aspirations. And this isn't just a question of us disagreeing over what a constitution should or can do in a particular case, you know, presidentialism versus, you know, parliamentary system or whatever it might be. Rather, it signals a deeper disagreement over the kinds of things that a constitution can or should generally do, or that should be given greater emphasis or first priority. And it's just because of the variety of the things that a constitution can do that so many diverse constituencies become invested in the constitutional debate, or at least or become not indifferent to it, particularly in the face of investment by rival constituencies. That answers question one in the abstract. Yet it's precisely that variety, and so the deep differences and disagreements that it produces, which also suggests the answer to question two, that it's very, very difficult to see anything coming of these constitutional debates. Note, crucially, that I do not claim the burden is one that is impossible to discharge, just very burdensome. Perhaps doomed to failure, perhaps not. What is more, and here lies the answer to question three, even if a constitutional solution appears but a distant prospect, it is not clear what else, if anything, would be fit for the mix of key purposes that such a solution would serve. The social and political forces, and I'll talk about them soon, that sustain and regularly revitalise the EU constitutional debate are powerful and constant and recurring. And just as it remains very difficult to see how a successful EU constitution can be produced, given the diversity of aspirations associated with it, with these forces, the very intensity of these forces and their various motivational attraction to at least some parts of the constitutional register means that it's also very difficult to see the legitimacy of the EU being enhanced in the long-term run without recourse to the high or big C notes in the constitutional register. Okay, so the point is, you know, it may not work, but it's very hard to get away from it. Now, how I want to pursue this argument is by talking about constitutional functions and saying something about the diversity of constitutional functions that you find in the EU. That, to me, is a key to the problem. But I'll start off by saying something about these constitutional functions in the state context, because part of my argument is that these constitutional functions and their interaction play out differently in the EU context than they do in the state context. But nevertheless, the state context is where they were initially embedded, and that's where we get the functional diversity of the Constitution from. Okay, and basically I'm saying that I'm talking about four different sorts of constitutional functions, right? Now, some of what I'll say here is kind of familiar because other people have said something similar, but I try to add to it. Basically, so, and here, the first two sets of functions I would call the kind of instrumental design and the integrative function. And there's lots of people who have viewed this sort of distinction. Dieter Grimm, for example, he talks in these sorts of terms. You know, the instrumental design function refers just to the basic normative or dogmatic content of the Constitution. You know, the formal constitutional text that establishes the machinery of government, rights-based constraints, inter-branch checks that limit institutional capacity, etc., etc. The second one, though, is the kind of integrative or the communitarian function of the Constitution, which tends also, it gets slightly less attention than instrumental function, but nevertheless people do talk about it. And the idea here is, through a variety of means, involvement in the constitution making process, investment in the so-called sacred text itself and its founding, ongoing participation in and valorization of the institutional life of the constitution, the political subjectivities it specifies, both offices and citizenships, and the key norms it articulates. Also the collective memorialization of the constitutional record, the constitutional patriotism. The constitution, through all of that, operates as a cultural vector concerned with the process of societal integration. In other words, the integrative function helps invest in the institutional architecture with the requisite social energy. Okay, so through this function, the constitution conveys and nurtures a set of meanings that encourage those addressed and affected by its design to develop and sustain a sense of the entity constituted as one in which they, in concert with other members, come to identify themselves, in some measure at least, as a community of engagement in a common form of political life. So there's this notion of the common form of political life, which is very important, as opposed to simply contingently overlapping interests. So there are two other sets of functions, though, that don't get so much attention. The third one is what I call the purposive function of the Constitution. So it's not just instrumental, it's not just social, communitarian, it's also purposive. It's a means by which a fundamental normative orientation for the polity can be endorsed. This may take the statement of the form of a statement of primary values, key objectives, state directives, whether market-based or socialist, or based upon some religious creed. It may also be expressed or implicit in more specific policy-centered provisions in the constitutional text, and that's increasingly evident in the more detailed style of constitution making of the 20th and 21st centuries. So there is a purposive function. I'll say more about that in a moment. Fourthly, though, the constitution typically also has a kind of ontological function. It says something about the type of polity that it's referring to. And this is usually, again, implicit. The constitution typically involves the presupposition of sovereign statehood. So there you have an implicit ontological function. It's claiming itself as, referring to an object which, by the very nature of its having a constitution, is a state. So it's making an ontological claim. But the ontological question, if you're talking about something which is a non-state entity, it can't just be implicit, it has to be explicit. So instead you'll have to answer that question explicitly for a non-state entity. So how do these various functions, instrumental, integrative, purposive, and ontological, how do they sit together normally? Now, the point is, in a state context, and we all know this intuitively as lawyers and people who work with these texts, is that for the most part, in the state level, this is it's very much an instrumental question. We think of the Constitution as an organogram. It's something which puts together various rules. It gives us the rules of political life, etc., etc. That's how we think of it, and we tend not to think of it in terms of its integrative, purposive, or ontological functions. Why not? Well, partly because for the integrative functions, it's because even though the ceremony of the Constitution is very, very important, for the most part, new constitutions are not they're not the integrative catalyst of political community, right? They are very, very important for the consolidation and the kind of the maintenance of political community, but they're not the catalyst for it, right? Now, in some cases they are, and there I think the American Constitution has a lot to answer for, because the American Constitution was an interesting example where the Constitution came before both state-making and nation-making. But in most other models, that's not the case. Take France, for example. There you had the state preceded the state preceded the cultural nation and the Constitution. In Germany, it was probably the other way around, but what you have is a very, very different situation where the Constitution itself, the constitutional text, is rarely the integrative catalyst. It's important for the maintenance of it, but it's rarely the catalyst. Also, in terms of purposes, one of the reasons why we don't hear very much about the purposive function of constitutions is that, the whole modern tradition of constitutionalism is about the expansiveness of the political, and the very idea of the political as being something which is not externally constrained, but is only, if at all, internally constrained. So a very sense of the constitution in modern constitution as being a symbol of political community militates against its own self-limitation. Of course, there is self-limitation in terms of rights provisions, etc., etc. But the interesting thing is that most of these limitations are side constraints. They're not actually manifesto limitations. You know, and I know I'm talking to a German audience here, and there's there's all sorts of ways in which we can challenge that in terms of the total constitution. I get that, I understand that, but what I'm saying generally in a comparative way, the emphasis and the bias within constitutions is towards an openness of purpose. Of course, there are exceptions to that. Socialist constitutions, fascist constitutions, religious constitutions, etc., etc., where you get a much more specific claim. But within what you see as a kind of traditional liberal democratic constitutional order, we don't tend to see these limitations, or we see them only at the level of very, very general abstractions, you know, about democracy, equality, etc., which are usually not even justiciable, tend not to be justiciable. So purposes tend to be tend again to be kind of implicit, to be under the radar. And as I've already explained, the ontological function is also under the radar. You know, a constitution, the making of a constitution is an affirmation that the kind of polity we're talking about is already a state, right? Okay. Beyond that, nothing explicit really needs to be said. So my point is that the instrumental function of state constitutions is predicated on the fact that their other functions are somewhat muted. You know, the proposal function is somewhat muted because there's a sense of the default sense of an openness of purpose. The integrative function is very much a consolidatory one or a reinforcive one, because the integrative catalyst has come from elsewhere, war, revolution, whatever it might be. And the ontological function is in a sense taken for granted, you know, because it's assumed that it is a state. So that is, you know, that's how I think within this oversimplistic model of the functionality of constitutions, how it sits together within a state context. How does this look when look at the EU? Sorry, I'm recovering from a cold, so I do need to drink water every so often. So I've only got a bottle. So how does this look in the context of the EU? Well, the interesting thing in the EU, much is different, right, in terms of how we think about these functions. But it can seem superficially that this is not true, right? Because as in the national case, the most prominent constitutional register is that of instrumental design. There's no doubt about it. Indeed, if you go back to Joseph Weyler's famous, well-known designation of the EU in the early 1990s as a, quote, constitution without constitutionalism, you know, that's exactly what he was saying. It plays to the fact that in the EU, there's long been a quite myopic concentration on the instrumental function to the neglect of others. Supranational Europe clearly possessed, from its 1950s inception, much of the institutional architecture we're long acquainted with from the state constitutional context. Indeed, as the architecture filled out over the decades, in many ways it became even more familiarly state-like. Innovations such as the direct elected European Parliament in 1979, the Charter of Rights in 2000, or the gradually increasing parliamentary role in the appointment of the Executive Commission over the last 2 decades, they all borrowed directly from the state template. But for long, this kind of restless institutional innovation existed only with very modest and uneven development of EU-wide political and political self-consciousness. And so the crucial point I make here is that, and so whereas in the national context, preoccupation with design questions normally signals both that the ontological question of polity type and standard is settled, and that the integrative question of engaged membership has already received an important threshold resolution, and is now largely a matter of reinforcement and consolidation. In the EU, the instrumental preoccupation has tended to signal precisely the opposite of this, right? Precisely the opposite of it. The relative neglect of any explicit attention to the integrative function of political self-identification, still less to the ontological question of the very nature of the EU polity, speaks to a variety of quite different considerations. Certainly in the early days of supranationalism, and of course if you go back to the history of supranationalism, there was a road not taken of political integration as opposed to economic integration. It may simply have revealed the remoteness of any strongly integrationist prospect, and indeed the absence of a policy agenda whose delivery would require the levels of mutual solidarity associated with a robust sense of collective identity, and so a consequent indifference to its consideration. Alternatively, I would say, though, and increasingly over the life of the EU, from the Messina Conference of 1995 to the 1992 project and the treaties of Maastricht and Amsterdam 4 decades later, such relative neglect of matters of politically integrative ambition and polity status spoke to a very different sense, to a sense that these matters would be so controversial and divisive that to make them central to any holistic initiative and any constitutional conversation around such an initiative might be fatal to the prospects of that initiative. Okay? And so, but if we actually look at the constitutional treaty itself in the early years of the 2000s, we kind of see how this plays out, and the very fact that we actually got over the line and actually had a constitutional debate was itself, a lot to do with the initiative of Giscard d'Estaing. In my paper, I say that this was something which was more grasped by Giscard d'Estaing than it was granted by the Council or sponsored by any of the other institutions. And basically, again, if you think about it, how the Constitution came about was very much within the context of the instrumental function. You had the Treaty of Amsterdam, then the Treaty of Nice, which was generally seen to be a failure. The idea that a whole bunch of things to do with qualified majority voting, to do with extension of competencies, etc., just hadn't been resolved. And there was a sense that maybe if you set this up with the additional gravitas of a constitutional push, and that's what many people in the Commission said to me at the time, if you call that a constitution, that would just give it that additional energy, which would mean that the kind of policy stasis was, the kind of institutional congealing which was happening in the EU at that time could be overcome. So even then, it was very much seen in instrumental terms. But the point is, once you have a constitution, once you have a constitutional debate, then there's a sense in which these wider constitutional questions become impossible to ignore, right? And so one of the really interesting things that happened during the debate was that policy issues suddenly became a kind of a proxy battleground for the broader polity questions. So there were people who wanted a small Europe, a Europe of economic club goods, and they tended to be people who said, okay, with a constitution, we could have a classic Bill of Rights, which can constrain what they do. We can have a competence catalogue, which can constrain what they do. And on the other hand, there were those who were pushing for all sorts of substantive policy reforms in social and welfare areas, which presupposed the kind of solidarity which you could only get by a more integrative, a more strongly integrated entity. So people seem to be fighting about policy, but behind that, behind the policy, the instrumental debate, there were other questions going on about integration and the ontological status of the entity that was being created, etc., etc. So that was there in the background, and all sorts of other things, like the very idea of the convention process was seen for many people as being very, very significant in terms of the integrative function. As you know, I said that earlier, part of what gives a constitution an integrative function is the very openness of the process of its making. So a lot of people jumped on that and saw that as being something which was very, very significant. As regards the ontological function, a closely connected set of concerns were evident. And that was one of the kind of hard areas, because so close is a connection between constitution making and statehood that probably the one largest reason why the two key referenda failed in France and in the Netherlands was precisely because those who were opposed to a quasi-federal Europe managed to make that symbolically that ontological connection between statehood and constitution, and said, okay, these people who want a constitution clearly want a state, you know, and you don't want that. You know, so these national referendum debates tended not to be about the text of the constitution at all, right? They tended to be about the very idea that it was a constitution. And of course, when the constitution failed, you know, the evidence of this, that this is the case, was that when the Treaty of Lisbon was passed in its place, it contained something like 98% of what had been in the constitutional text, but it just didn't call it a constitution. It didn't make these integrative claims. It didn't make these ontological claims. So, you know, the instrumental functions survived, but the other functions were lost. So, you know, where you see, you know, and one of the things that, you know, to kind of complete the picture here of what's going on, that the other thing that's very, very different about the EU constitution is that the purposive function has always been very, very clear. It's always been very, very much up for grabs, because it hasn't started from the premise or the conceit of an open-ended political mandate. It started from a very closed political mandate in terms of the economic good of the club good of economic integration, etc., etc. And every single part of the development of the constitutional architecture required continuing debate over these purposive aspects. Carlo Tuori's book, you know, on the many constitutions of Europe makes this very well. He says, look, the only way you can actually think about the European Union in constitutional terms was it had a microeconomic constitution, then it had a social constitution, it had a security constitution, etc., etc. Now it's moving towards a macroeconomic constitution as well. And the point he's trying to make is not just playing fast and loose with labels. He's saying that what you have to think of is that whereas we assume that the state constitution starts generally and then fills in its functions because it has such a capacious sense of its functions to begin with, basically the European constitution instead, because it didn't have that initial integrative momentum behind it, was something which had to be built up piece by piece in an aggregative way, you know, and that's why, you know, and that's how it's developed. And now the point is that, you know, the reason though that we keep coming back to the Constitution and the constitutional debate is that there's a kind of general recognition that the instrumental function is important. Of course it is, right? And just as it's important in the state context, but there's a sense in which the EU has still never had its constitutional reckoning with these other functions, which usually stand alongside the instrumental function. It's not had its constitutional reckoning with the integrative function. It's not had its constitutional reckoning with the purposive function. Various points it's developed in different ways. It's not had its constitutional reckoning with the ontological function. And there continues to be all sorts of debates about this on both sides. And actually, the way that people think about the Constitution isn't necessarily, you know, matched to their political label. So on let's say on the small Europe neoliberal right, and I'm using these terms very, very generally, very, very crudely, there are both those who say the last thing we want is to give this an imprimatur of a constitution, because that will just favour the federalists. And there's those who say, no, going back to the 2000 debate, it'd be good to have that because we can use the constitution as a constraint over the Charter of Rights or whatever. On the left, you have a similar division of opinion, you know, between those who, on the one hand, you know, are constantly suspicious of the big neoliberal project and they don't want to give it a constitutional authority, and those who, like the DiEM25 movement and Varoufakis' movement, who see the constitution as precisely the place where you develop the social energy towards an integrative function, which will allow a more sort of social Europe to develop the kinds of solidarity that you need, you know, to make these sorts of developments. So you know, there's all sorts of, there's no easy way of figuring this out. It's not that, you know, and in some ways that's a good thing. You know, it's not necessarily that, you know, that those who are on one side of a classic ideological left-right spectrum are in favor of a constitution, those who are against it. There are arguments for and against on both sides. So, so basically, where does that leave us? Well, you can see some aspects of this kind of dilemma being played out in on the conference on the future of Europe, and I recognise that I want to get to my final point, so I'm not going to spend much time on the conference, except to say that what you see there and what you always see is that every time there's a kind of big polity resetting initiative in the EU, it's always mostly about the instrumental function. It's about the working groups, it's about the policy platforms, it was about the 49 recommendations, etc., etc. It was all about new ideas, new substantive policy ideas, and some of the instruments associated with this. Much less about what you might call citizen building, polity building in the more integrative sense, although that was there, of course, also in the citizens' initiatives and on the online aspects of it as well. So there was a little bit of a tension there between trying to generate a sense of kind of solidarity amongst the citizenship, which would perform some of these constitutional functions, and just sticking with the tried and tested emphasis upon policy and institutional redesign. So we can talk about how there's a tension between these sorts of things, and I'll be happy to talk about that. I suspect Sandra will say some of these things, talk about some of these things as well. But what I would say is that, and this comes back to the point that I started with, the sense that, you know, there's a more kind of defensive posture now about the Constitution. It's more about sustaining rather than making something new. And what I would say was that if you look at the various crises of recent years, right, the crisis of fiscal capacity, which goes back to 2008, the crisis of border security, the migrant crisis, the crisis of the rule of law, with particular reference to Hungary and Poland, and democracy, the crisis of membership, Brexit, the crisis of public health, pandemic, the crisis of defence, now Ukraine, they all speak to the historical imbalance in the development of the Union's constitutional functionality. On the one hand, they all involve a tangible sense of the EU, of an EU-wide shared predicament that would not have arisen in earlier decades. Think back, 30 years ago, no one would have thought that the response to the pandemic should be something which was organised at a Europe-wide level. No one would have thought in terms of the fiscal crisis of 2008 as something which somehow came from and implicated the European centre, because actually there weren't the powers, there weren't the policy levers, you know, to create that situation. So the imbalance is that there is a kind of constitutional capacity. You know, you develop an area of freedom, security and justice, and you're going to have border problems. Of course you are. But once you have border problems, you have all sorts of issues about, you know, about dividing up responsibility for certain problems, etc., etc. Issues of clashes between the state level and the supranational level. Issues of distributive justice of all sorts, right? Once you have an enlargement program, once you become very, very explicit about your democratic credentials, then you cannot avoid the sorts of arguments and debates that you get with Hungary and with Poland, etc., etc. Once you become an entity which becomes more state-like, you cannot avoid something like Brexit beginning to appear more like secession from a state rather than simply leaving an international organisation. So the whole way in which all of these issues are framed has changed, right? And in every single one of these cases, there is you might suggest there's something like a kind of solidarity gap. You know, there's something like a shared response. We have the shared predicament, right? So the general increase in functions over the years creates all these new types of shared predicaments. But these shared predicaments can only be resolved probably through a measure and register of solidarity, which we don't have, of which we have less of. And that's why I think, you know, the constitution debate is both very, very difficult to resolve, because once you get into constitutional debate, it's precisely about these sorts of questions that the constitutional debate is engaged. But but there's a sense, you know, among some people at least, that, you know, if you want the combination of the way in which a constitution can fixate upon purposive, ontological, and most importantly, integrative functions, you know, it's the only way, or it seems to be the only imaginable way in which you can actually turn these shared predicaments into things which you can be reasonably sure you will get some kind of shared response. Now, it's very hard to make that argument without also turning it into an argument which necessarily favors a federal or a more federal Europe over a less one. You know, one of the things that I've puzzled over the years is to what extent we can try to treat the Constitution with its multifunctionality as a way, as a kind of honest broker for a process by which we work out the optimal way in which these different sorts of functions coincide, without necessarily that already having a strong inevitable weight towards a kind of federal Europe. All these questions, these are the burden of the European Constitution. So I'll leave it there.
Thank you very much, Professor Walker. Now we will have Professor Soriber. Please, Professor Soriber, the floor is yours. You are in mute.
Okay, now it should work. Now you can hear me. Okay. Yes, thank you very much for the invitation, and it's a pleasure to comment on a theorist who gave major impulses to the constitutional debate. So I'm very happy. I will follow up on the three questions and two statements in particular. I will not do justice to the rich arguments that Neil's paper gives, but highlight some points that I think are very important in the current constellation. So two statements. Neil says the EU constitutional debate has always been with us, but so far has not been successfully resolved. Nevertheless, it is very difficult to imagine how the EU can survive, how its legitimacy can be enhanced without recourse to the constitutional register. So it's difficult, but it's unavoidable. And indeed, I couldn't agree more. The social and political forces that make the constitutional debate necessary are powerful. They remain with us. And ignoring these forces just make problems bigger. The strategy of constitutional avoidance, as Jan-Erik Fossum calls it, has become risky to take. I will give some reasons for that, and we will see if there are any differences between my position and Neil's position on this. And yet, while the ontological question, what kind of polity the EU aspires to be, has always been around, there is only modest EU-wide political self-consciousness. And yes, that is the major problem. It's not only that a constitution with small or big c so far cannot fulfill any integrative function in the European context. It is even worse and serious. The preconditions for raising the constitutional question are constantly discouraged. That is the major problem we are confronting, and it should well be called a burden. Even after 70 years of integration, we cannot found a real European party. We cannot found a pan-European civil association. Think of Pulse of Europe. It has to organize under the German Vereinsrecht with all the difficulties that come with that. What you can establish is a European company, though, under a common legal roof. Société Européenne, an Europäische Gesellschaft. We have a common market, but hardly a common political space. So this is nothing new. It's well known. That is the burden, and it's unlikely to be overcome very easily and very quickly. But as I understand you, Neil, it can be overcome. So we will discuss this, I'm sure. In my short comment, I will just share a few reflections on the COFI with you as the most recent initiative to reset the European project, and then highlight some thoughts about a paradox of founding and the problem of beginning in politics. So the Conference on the Future of Europe was an ambitious experiment of transnational deliberative citizen participation. Citizens were chosen by lot and invited to deliberate about the future of Europe. The result are, you mentioned it, 49 proposals and over 300 measures put together in a final report officially handed over to representatives of the European institutions in Strasbourg on 9th of May this year. The final report contains a bulk of very important policy recommendations and more radical propositions for institutional reform. For example, abolish unanimity rule, trigger EU-wide referendum, change European election rules. So the constitutional register is somehow hidden in between proposals like increase student exchange and promote green production processes. And this is exactly what you say, Neil. From an educational perspective, this might be plausible, even advisable. People involved in the COFIs, citizen panels, come to the conference without having, they are chosen by lot and they might not have thought much about the EU and particular questions. So if you engage them in a debate on policy reform first, they will be more likely to realize themselves at what point it's impossible to move forward within the current treaty frame. To avoid confronting them, you avoid confronting them top down with the idea of a constitutional convention. Yet from a theoretical point of view, this is irritating. European democracy should be at the center and not one among other issues. It is the precondition which gives legitimacy to all other policy proposals and changes. Citizens' preferences for policy adaptations can be an important point of departure, but the great chance of the conference is that of political empowerment of European citizens to strengthen their position in the de facto constitutional order. So Neil argues that in contrast to the modern sovereign state, which started from a constitutional framework of legal and political authority, the EU has taken the opposite path, developing policy competences and a specific institutional architecture, thereby eventually paving the way for its constitutional progress. Moving beyond the incremental pattern creates a dilemma, either marginalizing the broader constitutional questions, thereby risking to further undermine the EU's legitimacy, or confronting them with an open visor and be again confronted with uncharted complexities and potential failure. So the first point to make is, and I think that you would agree, Neil, but I'm not sure, it's not a dilemma anymore. The path of constitutional avoidance has become far more risky than that of constitutional exploration. Times are different than 2002 and 2003, the failure of the convention process. If the EU doesn't take up the language of constitutionalism, well, others already do it. Think, for example, of the new strategy of constitutional Euroscepticism, for which Marine Le Pen's French presidential election manifesto is an example. It shows how the language of constitutionalism is captured by the far right. Le Pen promotes the progressive substitution of the European Union by a European alliance of nations, indirectly questioning, as others do as well, the primacy of European law over national law, but without saying it. So it's easier to sell constitutionalism, national constitutionalism, than it is leaving the EU. The bitter irony is that these forces usually don't care much about constitutionalism domestically. To counter this strategy, the EU must re-engage in constitutional politics. Constitutional Euroscepticism aims at making people think that the values of constitutionalism are incompatible with the European Union. But to the contrary, if given a proper push, the EU has the potential to reinforce them. We are in a struggle about narratives here. Second, think about the Next Generation EU Recovery Fund, a huge investment program of almost 2 trillion euros with which the Union reaches out to govern and shape the green and digital future. The goal is hardly controversial, but here again, not naming it as what it is and avoiding public discussion creates more than a dilemma. When Scholz, then as a financial minister, called the recovery fund a Hamiltonian moment for the EU, he was cautious to repeat this. Support for the COFI and the plea for a convention even made it into the coalition treaty of the traffic light parties. No word about it in the election campaign. Hardly anybody in the general public knows about it. But again, exercising power without raising into constitutional issues is risky, and that is the lesson learned from a decade of multiple crises. So I turn to the second part. Leaving the incremental path, we are confronted with a problem of beginning and a paradox of founding. There is much to be said about this. What I can give here is just a flashlight from a political theory perspective. So, new beginning, the essence of politics in Hannah Arendt's sense, is inherent in every initiative for acting. It is opening up a common world. If we apply Arendt's expanded sense of founding, it is clear that the constitution making is not accomplished once and for all, but needs symbolic renewal. The foundational act is a mutual promise, and it's continued through a practice of storytelling. This must also include the boundaries of the respective polity. It means reconstructing the democratic we to which the Constitution applies. To be brief, what is the story for the EU? My perspective is this. There have been constitutive moments constitutive for a structure of governance and authority, which incrementally made up the Union as it is today. The European Single Act, the establishment of a common currency, the introduction of EU citizenship, and just recently, the EU Recovery Fund, the Hamiltonian moment, to be continued, the rule of law mechanism, and a new European defense strategy. We have piled up and continue to pile up material constitutional moments, and we continue to do so, but they are to a large extent shielded from public debate. All these constitutive steps were and are still to a large extent established behind people's backs. It is not that people completely dislike them, as anti-European left and right-wing populists would like to make us think. So the Euro freedom of movement enjoy approval of 70–80%, as Eurobarometer data shows. And there are also indicators for solidarity. But what is missing is a sense of ownership, a feeling that citizens can influence these conditions. And this makes the EU extremely vulnerable. So can the COFI do anything about this? And here, let me end with a more optimistic picture, but also maybe, of course, it's an open question whether the COFI will create a momentum. It already provided, I think, a transnational forum for debating European issues. And given the lack of European public space, this is already something. Doing as much as possible on the current legal basis is good, but to continue the debate is even better. So ultimately, do what can be done within the current frame, but let the final outcome be decided in a European-wide referendum. The COFI can be interpreted as expressing and at the same time contributing to a series of constituent moments which might ultimately result in a renewed legitimatory basis for the EU. The reason is that I think at the moment, impulses from reform from above within the institutions come together with movements, pro-European movements from below, and this might well create a momentum, but of course that is a rather optimistic picture, with which I nevertheless close. I hope I was in time. There's some other points to be taken up, but that can be continued in the discussion. So let me thank you at that point.
Thank you very much, Professor Soriber. So let me now give the word to Professor Walker in case he would like to respond to Professor Soriber's comment.
Yeah, just briefly. Thanks very much. I really enjoyed your comment, and I kind of agree with just about everything you said. So it's maybe just pursue a couple of points, because one of the things that one of the things is very hard to get beyond, and I think you maybe put your finger on it, maybe inadvertently, but I'm not sure, is when you talked about competing constitutional narratives, right? And you made the point that there is a kind of anti-European but oddly itself transnational constitutional narrative, which is, I mean, the work that I've done on populism, for example, I think the thing that everyone underestimated was that the populism would have such transnational resonance. So you think, how can it have transnational resonance when they all hate each other, to put it mildly? You think, but no, there's a kind of sense there of the success, the cosmopolitanization of anti-cosmopolitan populism is really a phenomenon to ponder. And I think we see this, it was already there, I think, in the constitutional debate, and if you're looking for some of the ingredients of contemporary populism, you probably saw it in the way in which there was already a kind of mobilization of these forces at the first constitutional debate against that. And that's a hard one, because it means that, we're constantly, I think you agree with me that only a constitutional frame has the comprehensiveness of remit and the self-conscious political reflexivity necessary to actually force people to actually confront what's at stake in all of these sorts of questions, right? And I would want to make the claim, and I think you probably would do as well, is that everyone should do this. This is not something that, the idea that it reminds me so much of my Brexit debate. I feel like saying, look, I'm you're just wrong. Like, there's a kind of sense in which you think, okay, if we get down to absolute basics and you want to maximize voice and agency, right? You're not going to maximize voice and agency through Brexit. You're not going to maximize voice and agency through, containing with a kind of mythical sense of a kind of, sovereigntist Europe. So part of the trick is to try to encourage people, regardless of how far they might want to go with this, because there's going to remain all sorts of fundamental issues about how far mutualization of debt, common fiscal resources, how far these things go, and all sorts of issues about, the movement from national to transnational welfare policy, certainly stuff about security. And the trick is to try to say to people, look, there is a necessary minimum of common political energy which is required, that sense of a common political space, regardless of how you actually want that to be resolved. Unfortunately, we don't seem to be in that place. And one of the things that I think right-wing populism has done very, very successfully is to continue to make that connection, saying that anyone who wants to talk about the EU constitution, or anyone who wants to talk about the EU in cosmopolitan terms, is necessarily pursuing a very, very thin, a very, very particular and very ideologically driven political project, rather than saying things which are just general truths about the nature of the political and the globalizing world. And that, I think, is very difficult, to overcome. I like the sense of the, how we, one of the things you did, which I don't really do in this paper, at least, I think, is you give a nice sense of how, how these things can be kind of, incrementally developed. There's always a danger in this debate, and it's something I had various debates with people like Dieter Grimm over the years, but also my friend and colleague Martin Laughlin, who kind of essentialize the notion of the social or the integrative. Either you are a nation and you have a sense of yourself as a common political community, or you don't. And that, in its extended form, it also becomes one of mutual exclusivity. You either have it at the European level or you have it at the national level. And of course, you're saying something different, saying, look, no, this is something which, it has to be built. It doesn't come magically, in any particular context. It always has to be built, and it certainly always has to be sustained. Now, I was making the narrow qualification of that, which is to say that, yeah, I think the integrative function is actually massively important for national constitutions as it go on, but it's something which kind of takes place under the surface. It's something which is there, and it's not as prominent as the instrumental function. And the point I would make is that, unfortunately, there's a difference between essence and catalyst, right? The point is that often there's a catalyst for the making of a community, and a constitution can be very, very important, and I think in developing the generality of political community. Historically, in the state context, with some exceptions, it tended not to be the catalyst. Often it was a consolidation of the catalyst, right? But it tended not to be the catalyst in itself. And that leaves us with this difficulty in the EU that we're expecting the Constitution to do an awful lot of the social and symbolic heavy lifting of the making of political community. We just are, right? And that's a difficult thing to do. That's just a difficult thing to do. And I think what you're saying is that a lot of these, let's call them quasi-constitutional episodes like the conference, at least what they can do is that they can actually push forward the kind of procedural envelope. They can say things like, okay, I like that notion within it, saying that we've had citizens' initiatives. So one of our proposals is that there should be more of the same. There should be more citizens' initiatives. And there you see a reflection of what you found within the constitutional treaty as well, that that we've moved towards a convention. So let's institutionalize the convention as a procedural method which is now legitimate within the EU polity. So at various points there's a ladder of procedural advancement and ambition, which I think can actually make a difference. It can make a difference. But it's important. It's important what happens next. It's important that the people who came out of that said, okay, 6 months from now we're going to convene new citizens groups and see how far these things were done. It's also important, I think, and I've read this in a couple of the critiques of the conference, that somebody made the point that let's call it mini deliberative democracy contexts, like the citizens, initiatives, are an important part of democratization, right, of the union. But the point being that if you think of that as being one flow of water in the direction of democratization, it's still dealing with this other flow, right, which is Kaczynski and Orban denying, European democracy, which is the very fact that we're taking on all of these new functions without necessarily having the democratic support to justify taking on these functions. So it would be unrealistic to say that all that's happening is a kind of incremental progress towards a goal. Yeah, it's one of the forces. It's one of the forces, but against that, there are other forces. There are forces of what you might call democratic decay or de-democratization taking place at the same time. And, that's where it's really important that we don't just focus upon the citizens' initiatives. We also focus upon, as you said right at the beginning, this, this incredibly, sort of rare beast of, the European political party. How do we actually get that going? And there have been incremental developments there. And it's as much about that, I think, as it is about these other softer, more bottom-up forms of democratic innovation. But anyway, I think we should throw it out to the audience because it's I've talked enough. or unless Sandra wants to come back at the moment, I don't know.
I think it's great if we open to the audience now. I could come back, but I think we should give the others a chance to intervene.
I agree.
Let me thank the two of you for this insightful talk and comment. And we are going now to stop the recording.